Good morning, everyone, and welcome to our May version of the Gardiner Roberts Toolbox Seminar. And I'm really pleased we had good weather this time, because you'll recall at the February session we had a snowstorm and we had trouble getting our speakers here, but no problem today that way. So welcome. Today our focus is going to be on some of the recent proposed changes in budgets, both federal and provincial, as well as an update on a continuing problem with trust and the 21-year deemed disposition rule, and then a little bit of a different theme, still trying to talk about current matters. One of our senior excellent corporate lawyers is going to be talking about some of the changes encouraging diversity in the workplace. So our first speaker is Arlene O'Neill, and she'll be speaking on that current topic. And I think you'll hear some things that surprise you about changes in corporate law, such as the Canada Business Corporations Act, as well as practices. Then I'll be speaking about changes in the federal and provincial budgets from a tax point of view, and touch on things just a little bit beyond the typical income tax. Bill Bernstein will be talking to us about some changes in the administrative policies of the Canada Revenue Agency and some workarounds to try to still defer, if we can, that deadly deemed disposition 21 years out. And Pamela and Liang will expand a little bit on a topic that I'll just touch on in the federal budget, and that's trusts, the new disclosure rules, and how that fits into the overall movement, I would say, initiated by the financial task forces and the OECD to require disclosure, beneficial ownership, who's involved in companies, who's involved in trusts, how far that's going, why, and some of the things we need to think about. So let's start with Arlene. Oh, one thing, you've got evaluation forms, and I always remind you, please fill them out. They're very helpful to us to see what we can do better and things you're interested in. At the end, we'd appreciate if you could just fill in the forms and leave them.
Good morning, everyone. I apologize for messing up your schedule this morning. I have a transaction closing, and so I have to run off promptly at 9 a.m. So I'm here to talk to you this morning about changes in the law to encourage diversity in the workplace, and we thought that this was a timely topic. Sorry, I apologize to figure out how this is working. Given I'll call it the Me Too movement. And I think also, obviously, I think sexual harassment and issues around the employment workplace are becoming more and more a mainstream news on a daily basis. So I thought we'd talk a little bit about the legislative framework in Ontario and Canada and how it's evolving and changing. And so I'll call it a lighter topic compared to tax that's coming up next. So in Ontario, as I'm sure most of you are well aware, there was Bill 132, which was implemented in 2016, which had covered the issue of Sexual Violence and Harassment Action Plan Act. There is also the Ontario Human Rights Code, which underlies protection of individuals in Ontario against harassment. On the federal level, there is Bill C-25, which is proposed changes to the Corporations Act, Competition Act, Not-for-Profit Act, maybe a few other acts relating to encouraging diversity, disclosure of diversity amongst directors and senior management of public companies. Then there's the Employment Equity Act and BC-65, anti-harassment. There is also locally at the TSX, the Board of Directors Diversity movement, and finally, a little bit of note on a few things happening in the Me Too movement, which is in progress and always ongoing. So giving a bit of background, in Ontario, Bill 132, Sexual Violence and Harassment in Action Plan Act. This act came into force in 2016. It amended the Occupational Health and Safety Act and imposes positive duties on employers to foster harassment-free workplaces. Employers are required to investigate complaints of workplace harassment, failing which the Ministry of Labor may order an external investigation at the cost of the employer. Employers are also required to establish written workplace and harassment policies. And obviously, if you fail to do so, not only do you suffer consequences or potential consequences under the Act, and the minister may put costs and have an external investigation, you can always also face liability under Ontario Human Rights Code and in front of the Ontario Human Rights Tribunal, which is costly, time-consuming, and extremely unpredictable. BC 25, there's proposed amendments to BC 25 and draft regulations dealing with diversity, which would require publicly traded corporations to disclose information on diversity amongst their directors and in senior management. I'll talk a little bit about the TSX a little bit later, but the Bill C-25 is intended to apply to all public companies, which would include Venture Exchange. The measures mirror those already required by provincial and territorial regulators, except BC and PEI, which don't have anything in place. Then there's the Employment Equity Act. The purpose of this act is to achieve equality in the workplace, so no person shall be denied employment opportunities or benefits for reasons unrelated to ability, and to correct conditions of disadvantage in employment experienced by women, Aboriginal peoples, persons with disabilities, and members of visible minorities by giving effect to the principle that employment equity means more than treating persons in the same way, but also requires special measures and the accommodation of differences. So I'll call it very sweeping. A lot of these things are difficult to interpret and big unknowns for corporations and employers. Back to Bill C-65, anti-harassment rules. So on November 2017, the government introduced Bill C-65 to create a single integrated framework that will protect federally regulated employees from harassment and violence in the workplace. What's interesting, of course, is this is federally regulated employees. It's not private. So you're going to be relying on provincial law to protect private company employees. You will also see the workforce. This chart shows you the percentage of men and women in the federal public sector, and it's a little small, but you will see that women in the federal government workforce represent 55%. So, you know, it is quite a large issue within federal public service. It also amends the Canada Labour Code and Parliamentary Employment and Staff Relations Act and Budget Implementation Act. The major issue with the bill, as I said, is does not help those who are working in the private sector. One of the things that this does is federally regulated employers would now be required to take prescribed measures to prevent and protect against harassment and violence in the workplace, respond to occurrences of harassment and violence in the workplace, and offer support to employees affected and violence in the workplace. I think you've heard things in the news, for example, the RCMP, you know, this is the type of employer that this is now going to apply to, where women have complained of long-term and systemic harassment. So I think these are obviously good changes and something that is needed in workplaces where you may be covering emergency services, et cetera, and heavily, probably historically male-dominant and male-dominant in the more senior roles. What is also interesting is the existing law allows federally regulated employers to request an exemption from establishing workplace health and safety committee, where they essentially have a good track record, this exemption would be repealed. So everyone would have to comply. There is also protection of privacy. So another notable change is complainants of the workplace harassment or violence would be protected. And it goes quite extensive into how they would be protected, in that workplace committees, policy committees, and health and safety representatives would not be permitted to participate in an investigation into workplace harassment or violence, and would not be provided with any information that is likely to reveal the identity of a person involved unless they consent. So it's allowing for great secrecy. I think the other thing is, even though this would apply to public service, it is a good heightening of standards that presumably could also be rolled out by the provinces to the extent they're not this specific in measures. Turning to the TSX, Board of Directors Diversity. So as I said, the TSX has kind of a report and I'll call it an encouragement program to report on diversity. And this only applies to TSX proper companies. It does not apply to venture. After implementation of this, the TSX initiative, as of July 31, 2017, the percentage of companies without any women on boards fell to 37%. The average number of women directors per company is up to 1.13 directors versus 0.96 in 2016. 47% of S&P TSX 60 companies have now adopted a target for representation of women on the board, up from 39%. So 47% now, up from 39% in 16. So obviously the implementation is having an effect, but it is still in need of some progress. Women now hold 14.5% of all board seats amongst all companies disclosing the number of women directors on their boards, and 26% of the board seats for the TSX 60 companies. 47% of companies disclosing indicate they have a written board diversity policy, and what has remained unchanged at 15% is the average percentage of executive officers who are women. So women on the board is increasing. Women at the executive management level it remains unchanged. So National Instrument 58101, Disclosure of Corporate Governance Practices, requires non-venture issuers in Manitoba, New Brunswick, Newfoundland, Labrador, Northwest Territories, Nova Scotia, Nunavut, Ontario, Quebec, and Saskatchewan and Yukon to disclose certain information regarding women on boards and in executive positions. So I think, as I said earlier, BC and, sorry, one other province, PEI, I think, are not on that list. And so at the federal level, the bill C-25 presumably would assist in that. Now, the 2018 federal budget, I'm not talking about tax, also claims to set a new standard of gender budgeting as a core pillar of budget making, legislating higher standards and making meaningful investments towards greater gender equality, underpinned by clear objectives and strong evidence, according to our current government. C-65 was one of the measures implemented by Canadian Parliament in response to the Me Too movement. And just talking a bit, I think I have one thing that the federal government put into their announcement, which I thought was interesting, about how they're going to spend money on diversity. They are going to allocate $19.9 million over 5 years for a pilot apprenticeship incentive grant to provide women with up to $6,000 while training in male-dominated skilled trades, such as welding or pipe fitting. Other measures include $1.4 billion over 3 years from the Business Development Bank in new financing for female entrepreneurs. and $105 million over 5 years to help the regional development agencies support women-led businesses. So I think that's actually positive and encouraging women in the executive and board roles. Now, on the Me Too movement, I think we've all seen lots on that. To analyze the case law, it doesn't seem enough time to have elapsed to understand the full effect, obviously, on the movement and also that these changes may have. Bill C-65 does appear to be the only federal action in direct response to the movement. And the Me Too movement, I'll say, is a work in progress. What is I've found recently in the news that also is useful, the 21 best countries to live in the world if you're a woman. Canada now places 6th on that list. The U.S., which everybody always wants to know, well, Canada's where and the U.S. is where. U.S. places 16th and the U.K. is 13th. So I think Canada is on the rise. The Nordic companies seem to take the top 3 spots. And so I think that's good news. I'll call it good news for Canada, or at least positive news for Canada. One other interesting thing I saw on the CBC the other night is that women are now actually establishing, I'll call it women-only workplaces, that they're essentially, people are establishing offices and women consultants, entrepreneurs are renting a desk or renting a desk in this office facility where it's only women allowed. And they're working there and they're having, so they have socialization, with other women who are in the same kind of position. It's actually a huge movement in the US. It's come to Canada, and I think it's growing. So it's Hillary Clinton has said this is a great thing. It's a great thing in that women are showing they're not going to stand for it. Things are going to change, and we're not going back. So that's my commentary on the Me Too movement. Enjoy your tax.
Thank you, Arlene. I'm going to talk about the budget changes. Think of one item I can link or relate to what Arlene has been saying, and that is, Oral, do you want to come up and help me with the session? You may remember, those of you who were here or listened to the talk that I gave about the proposed taxation of passive investments in private companies. And one of the major problems was going to be with, let's say, a professional corporation, and in the press, there was a lot of discussion about women doctors, let's say, setting up a professional corporation, and that these rules would be particularly harsh as against that group in society. And I'll talk a little bit about the clamor and the complaints and the changes the government made, but it's a little surprising that the same government that was proposing all these positive gender changes were tone deaf to what they were doing in the passive investment area.
I'd say it's only spending changes.
Fair enough. So I am going to talk about the personal income tax changes and corporate tax changes. One area in HST that has a major effect on business, particularly syndications, a little bit on the proposed marijuana tax, and touch on the Ontario budget. So the first item I've got under individual tax rates, there's going to be a lot more discussion that Pamela will go into later on. I'm just making a note of it here so that we're all aware of this increasing movement across the world that is going to require the change in disclosure rules. There's no more bank secrecy. Confidentiality is almost totally gone. Solicitor-client privilege is one of the few areas that's left. But now governments all over are going to be requiring disclosure of who owns companies, who the shareholders are, not just who the directors and officers are, because that's been publicly listed for a long time, but who the owners are is going to be required, and now we're seeing it in the trust area. So the no individual tax rate changes. We are still looking at a combined top rate of close to 54% in Ontario. And looking south of the border and the changes that took place in U.S. tax reform, we talked about this a little bit at the last session. While personal rates weren't dropping as dramatically as corporate rates, they did drop, and our government, having been questioned about, are we going to respond to that, said, we're not going to have a knee-jerk reaction. In other words, no. Is that the way in which we can remain competitive? I'll leave that question for you to think about. The at-risk rules for tiered partnerships. I mention this because while it has resonance in our firm because one of our clients was the subject of the tax court case and affirmed at the Federal Court of Appeal, it's just, I think, an interesting matter. A number of tax shelters over the years created two tiers of partnership where the investor came in at the top, investment capital was put into another partnership at the bottom, and that partnership would acquire property. If they did a good job, there were losses incurred that were reasonable that could be written off. We have at the limited partnership level rules that say you have to have an at-risk amount. In other words, enough capital invested at least equal to the losses you're trying to have distributed. But when you have two tiers, what happens at the top tier? And that was the matter that was litigated because the top tier claimed all of the losses not subject to the at-risk rules. And initially, the CRA said that couldn't possibly be right. The government policy was to have the at-risk rules apply in limited partnerships generally, but the court said you had to be more specific. So the case went through successfully for the taxpayer, but the government changes the rules. Of course, when they lose, that's what Parliament has the power to do. So from now on, if you have two tiers of limited partnership, you have an at-risk rule at the bottom, it's going to be the same at-risk rule at the top. You can't avoid that limitation. Private company tax planning. So again, the context here was that in last summer, the government came out with a number of proposals, many people called them draconian, that tried to make the argument that people who have successful private businesses have a significant tax advantage because if they're only paying either 26.5% on regular income or they have the small business deduction and they're paying 15.5%, they have more after-tax dollars in the corporation than the comparison with an employee who, let's say at the top, is paying 53.53%. And so that's not, they say, horizontal equity, that's inequitable, and we're going to impose upon the corporate owner significant tax increases, the end result of which would have been looking at the income that's earned from business and then investments, generating investment income, paying tax, not getting a refund when a dividend gets paid out, but then being taxed in the individual's hands, the aggregate, instead of in our integrated system being 53%, whether it's direct or indirect, would have been 73%. And it was an amazing clamor from the public right across Canada. Something like 30,000 submissions came in complaining about that, which is unheard of in a federal budget proposal. And then gradually over the fall and into the winter, the government started to back off. And in the end result, it probably is a good thing that the government was forced to reconsider, because I think they came up with a plan that made a lot more sense in terms of good tax policy. But part of what is really strange about this, again, they were looking at the corporate benefits from the low tax rate and generating all that after-tax income, tax sheltered, so to speak. So what do? They lower the rate for small business. That, to me, is illogical, but this is part of the politics of it. They have to give something back. So the federal rate is reduced for this year by 0.5% from 10.5 to 10, and for next year it's down to 9%. Ontario, and I'll get into this a little bit later too, is following suit. So the aggregate falls from 15.5% last year to 13.5% this year to 12.5% next year, which is a very low rate for the first $500,000. Now, the interesting thing in how they changed the policy is limiting access to the small business rate. And as I say, the widespread criticism and a significant reversal. Here's how it works. And I've got a chart on the next slide just to show you, but the explanation is here. The lower rate was brought in many years ago in order to enable entrepreneurs, business people, to use the after-tax dollars, grow the business. They have might have trouble borrowing from the banks. They need protection against volatility in business. And so here's a way for the government to give an encouragement to grow businesses. But if the businesses become big enough, they can go to the banks. They can withstand volatility. And so maybe the small business rate should be capped if you're small and not if you're large. And this is the approach that's taken. It's already a little bit in the government, in the rules in the Income Tax Act. It's been broadened. So the lower rate will be phased out on a straight line basis. If you have a group of associated Canadian-controlled private companies, CCPCs, with capital between $10 and $15 million, there's a limitation. And we have to look at the investment income earned out of those after-tax dollars in the corporation. The first $50,000 will not be affected by the new rules. But as you start to generate more capital, generating investment income on that capital, the small business rate gets gradually reduced. So it's a reduction of $5 for every dollar of investment income above that exempt $50,000 threshold, with the result that if you have, say, $1 million of extra capital generating $150,000 of investment income, no more small business deduction. And in this chart that comes from the federal budget papers, it shows how there's an area that is not affected by the changes, but as you see the investment income on the top increasing, the availability of the small business deduction is reduced. And complementary to this is the refundable dividend account. The idea with integration in private companies is that if a Canadian-controlled private company generates significant capital and there can be investment income, the government doesn't want people to put their investment income into companies and get a deferral as compared with holding the investments personally. So there is a very high initial corporate tax rate applied to that investment income, close to 50%. But if that company pays a dividend out, there is the ability to get a refund of that corporate tax. And at the individual level, there's a dividend, but with a dividend tax credit. So with the refund on the corporate side, with the credit on the personal side, we have integration. The total is 53.53% on investment income, which would be the case if it was direct or indirect. Now we're going to have two accounts to keep track of. One is eligible refundable dividend tax on hand, which looks at specific refundable taxes that come up under Part 4. That arises when a private company invests in the market has a portfolio and earns investment income from public companies, it has to pay a tax of 1/3 roughly on those eligible dividends. That goes into an account, and that the tax initially paid can be refunded later, but it's out of eligible RDTOH that dividends are eligible dividends. So we've got non-eligible and eligible to keep track of. Imagine small business owners trying to keep track of this. And there's a second refundable account called non-eligible RDTOH. This is a little trickier. Let's say you've got a holding company and an operating company, and the operating company has this investment income coming in, or just additional tax that it's paying, and it pays a dividend up to the holding company, and as a result, it gets a refund. But the holding company now has tax that it has to pay, so that within the system, you can't avoid that equivalent of the Part 4 tax. So the non-eligible RDTOH looks at those dividends within connected groups or associated groups. And you can only get a refund from this account if you pay a non-eligible dividend. And there's an ordering, so you have to clear all your non-eligible dividends out first before you can get at your eligible dividends in the RDTOH account. Again, this is for Canadian-controlled private companies. This is not for multinationals. Imagine what business people have to try to keep track of in their accountants. It's going to be a challenge. And here, it may be even more so. You may recall that as part of the package back last summer, the government was very concerned about so-called income sprinkling. We've had the kiddie tax in the Income Tax Act for a number of years. If you've got a family corporation in business and dividends were being paid out on various classes of shares, if one of the dividends went to a minor and it was as a result of, let's say, the father or mother in control of the company, that would be taxed not at that minor's low tax rate, but at the top rate. And that was to prevent what was viewed as inappropriate income splitting. It's now been expanded, and these rules are really difficult. They've been modified slightly because of the clamor, but still, in my view, they're going to, from a tax policy point of view, hard to understand in the first place, very complex. Secondly, hard to comply with if you don't understand them. And then thirdly, it's going to be hard to audit them. The auditors aren't going to understand it. Very bad tax policy. And the government, I'm not sure that they're being completely open about all of the implications. The budget parliamentary officer estimates that these tax changes will result in revenue, increased revenue for the next fiscal year, 2018-2019, by over $350 million, whereas in the budget, the Department of Finance estimated $190 million. It's quite a difference there. And then by 2022-23, the budgetary officer estimates $429 extra million of revenue versus the government less than half, $220 million. We start with this construct. It's presumed that the tax on split income is the term that's given, TOSI. These rules will apply to an individual who earns income from a private business, and it's any form, dividends, interest, partnership allocations, trust allocations, or capital gains. You're caught unless you have an exemption that applies. So all of Canadians who have any involvement in a private company have to be aware of these rules. I have a chart, and it's a little hard to read in the actual brochure, so there's an insert that's larger and hopefully legible for people to be able to see. But I found this a useful chart. There's a tax service called Wolters Kluwer, and each month they come out with articles. But this particular working chart I found very helpful. If you go through this yes, no chart, you're able to wend your way through to see if the TOSI rules apply or not. So starting at the top and briefly looking at amount received from a related business. That's, again, if a father or mother is involved in a partnership in a corporation and one of the family members gets this kind of distribution of income, that's a related business. And a specified individual is that person who's related to the person who is in control. And then we first look at whether that person has attained the age of 17. If they're below that, the kiddie tax applies. So this is for adults. Is the amount from the disposition of a qualified small business corporation share, that's the term that will enable a vendor to claim the lifetime capital gains exemption. So that still remains a viable planning tool. There were proposals to limit, particularly through the use of trusts, the exemption, but that was dropped. So this is still an incentive to be able to create structures whereby people can realize tax-free capital gains for farming, fishing property, and so on. If you fit into that category, then go over to the left, yes, and go all the way down. The TOSI rules do not apply, so that's great. Now we know one way of an exemption. But what if it's no? Then we go down to the third box. Has the individual's spouse or common law partner attained 64? And would the amount be an excluded amount? In the next slide, I explain a little bit about that term. So if you are age 64, you're okay also. You can be excluded. But the next box down is the amount from an excluded business. Again, I'll touch on that in a moment. Then you can be out. If it's no, has the specified individual attained the age of 24 years? And here's where it really becomes difficult. The age brackets have different definitions, complications, and implications. So if you have not attained 24 years, you go up to the right. Is the amount from property inherited from a parent or from a specified individual, and so on. If the answer is yes, then you can be excluded, but if it's no, is the amount a safe harbor return? So they look at a prescribed rate of return on capital, and if you're within that narrow band, you're okay. But if you're not, then is the amount a reasonable return, having regard only to contributions of arm's length capital? Another very unclear term, what is reasonable? In the international context, we've got transfer pricing rules between big multinationals hiring expensive accountants and lawyers to do very complicated calculations of what's reasonable. This is for private companies that don't keep track of time and effort of family members, but that's going to be the expectation for everybody in Canada who is involved in a private company. Rather incredible. Just briefly, I list here some of the highlights of the definition of excluded amount. It includes gains from inherited property, provided the individual has not attained the age of 24 years. Income from an individual who has attained 17 years if it's from an unrelated business. For individuals between 17 and 24, there's a safe harbor based on the prescribed rate of return, arm's length property investment. For an individual who has attained 24, income from an excluded share, which is a share of a corporation carrying on a non-service business. So if it's a professional, going back to what I said before about a lot of complaints from women doctors, that's a service business. It's not excluded, but coming back to here. So if it's from a non-service business and in which the individual holds at least 10% of the shares or attains a reasonable return on capital, that can be an excluded amount and not subject to the TOSI rules. An excluded business is a business in which the individual is actively engaged on a regular, continuous, and substantial basis. So what they're really getting at here is somebody who's in university and working part-time, this is not going to be an excluded business because they're not meeting these factual tests. even though they may make a very significant contribution. Question, Murray?
They haven't theoretically touched salary, which seem to go unaudited because everyone's talking the same thing, but they're not important. Is this going to eventually get the salaries? Are they going to start auditing salaries more, or salaries going to be the way out?
They haven't. The question is, I've talked a lot about investment income being generated and passed out, and what happens with salary? Is that going to be the way out? How are private companies going to deal with that? There's always been a risk that if, let's say, a husband is in the business and brings the wife in to do bookkeeping and pays a very significant salary, is that reasonable? Is that going to be challenged by the CRA? And I would say that it's, leaving aside these changes, the risk level has increased on the question of salary to family members in any event. I don't think the government needed to change the rules here for the CRA to administer salaries. I think that is untouched technically from these new rules, but there's still something that have to be looked at very carefully, because governments are looking for revenue everywhere, and unusually high salaries that can't be justified are going to be at risk for sure. Let's turn to international tax measures briefly. There are a number of changes here, not huge differences in the system. It's going to be maintained, the same thing with active business income generated in foreign affiliates in a very beneficial way. Foreign accrual property income applied to passive investments offshore, still something we have to be concerned about. But in the last while, there have been a number of structures the government has become aware of where people have set up companies with so-called tracking shares, where a separate class is set aside for, let's say, a Canadian investor, and the company itself, and it might be a cell corporation with different cells and different shares issued for each cell or not. The company itself has 6+ employees and tries to meet the test of being a foreign affiliate engaged in an active business. And the government said, we don't like the tracking share concept, because what you're really doing is taking advantage of other people's investments unduly. We're going to look at each particular separate tracking class or cell and say that's a separate business giving rise to FAPI, and you're going to have 5 employees for your class, not just for the whole company. And then the other point that I think is worth emphasizing, again, I talked about this at a number of our sessions, is the sharing of information. Arlene has talked a little bit about changes to the federal statutes, the business statutes, where the Canada Business Corporations Act is moving towards a disclosure of beneficial ownership of shares and an elimination of bearer shares. The latter, I'm surprised that Canada has retained the ability to create bearer shares, because even tax havens like BVI have been forced to do away with it by the OECD. And Canada here is really just catching up. But just think about this. This is all companies, not just public companies, but even private companies are going to have to disclose beneficial ownership. And what happens with that information? That now is being proposed can be shared by the CRA with Canadian police officers and officials in foreign countries where we have a convention on mutual administrative assistance in tax matters. So this is the United States, the United Kingdom, and many other countries around the world that may not be as respective of the rule of law, but these mutual assistance partners can get this information on the basis that they say they're investigating serious crimes, such as terrorism, organized crime, and money laundering. So the confidentiality of the tax system, which is, to me, a fundamental foundation to giving people the confidence that they can tell the government about their affairs, because it's going to remain confidential, now here are these changes. They can be perhaps justified on the basis of these prevention of serious crimes, but it is a significant erosion in confidentiality. HST, briefly. I talked about the two-tier limited partnership structure in the income tax context. Well, it's very often a syndication, let's say a real estate, is put together in a limited partnership. And the general partner is charged with the responsibility of managing the partnership. And when there's a distribution going to the limited partners and something to the general partner would like to say, this is not because I have made a taxable supply to the partnership. This is just a distribution like anybody else gets. And it should be free of HST. Well, the federal government says that is too sweet a deal. What you are really doing, general partner, is you are providing a service to manage or administer the partnership, and the fair market value of that service, whether you charge it or not, based on what you get or what you ought to get, is going to be subject to HST from now on. So it's a major change, and it applies to what's called an investment limited partnership. And that's one in which the purpose is primarily to invest in paper, in other limited partnership interests, in stocks and bonds and so on, but not real property. So if you're structuring a syndication of real property, the bottom partnership, which has real property in it, can make a distribution to a general partner and not be subject to HST. But if you're creating tiered partnerships where up above investors are coming in and they're just investing in other partnerships, the general partner of those will be subject to HST. So it takes some effort to try to structure those properly. Marijuana tax, just very briefly. It's going to become legal this summer, apparently, and we're finding a huge increase in value for public companies. Heather's seeing this in the marketplace where unbelievable prices. It reminds me of the Nortel days when people were paying for companies that had no income, certainly no net income, but apparently revenue. And it's hard to justify revenue when it's not legal, but that's what's happening in the marketplace. So the government is going to take a piece of the action, and there's going to be a new excise tax at the higher of A and B, a flat rate applied to the quantity of cannabis contained in the final product, and B, a percentage of what's called the dutiable amount of the product, and that's looking at the quantity of cannabis contained in the final producer's selling price that excludes the cannabis duties. And the government, I think, expects to get a significant windfall from this. But I think we have to be very cautious about this approach. The government has, as I understand it, proposed these changes to legalize cannabis to get it away from the gangsters, the underground economy, to bring it out into the open. And so they have to be careful, because if they raise the taxes too high, look at what happened with tobacco. Tobacco goes underground, and you find contraband tobacco sales go way up when the taxes go up. So the government hasn't really addressed this, but I just suggest we should watch for this very carefully. And apparently the governments federally and provincially have agreed on revenue sharing, federal to take 25% and the provinces 75%. Finally, the Ontario budget. So when you look at the tax rates provincially in Ontario, there is a surtax that's applied on personal income tax. It still hits a maximum of 53.53%, but what the Ontario government has done is it's restructuring the rates a little bit and removing the surtax, but in the end, the top rate isn't changing. It's still 53.53%. For corporations, the Ontario budget announced that they're generally going to follow the federal government. So for the small business rate, as I mentioned earlier, this year it's down to 13.5%, and next year down to 12.5%. And they are also going to follow the phasing out of the small business deduction, as I mentioned before, investment income. And they're adopting the TOSI rules, and they've agreed on the sharing of revenue from cannabis taxation, but they haven't said where their 75% is going to go. Is that going to go to further expenditures or going to the municipalities? Or we don't know. And then the final point, and this could be a whole presentation on its own today, Ontario has a cap and trade system that they've recently brought in to try to reduce carbon emissions. And they've announced linking our Ontario cap and trade market with the two others in North America that have a similar system, Quebec and California. That is supposed to be Ontario's equivalent of a carbon tax. The federal government, as you know, has announced that they want to impose a carbon tax nationally, and that they want every province either to agree to have the carbon tax applied or have something similar to that. We know the politics right now in several provinces, including our own election, a lot of opposition to that carbon tax, as well as the cap and trade market. Certainly, Doug Ford has expressed his reluctance to continue with that. So right now, all I'm going to say on that is just keep an eye on it. It's a moving target. So that completes the presentation that I wanted to make on this, and I'll turn it over to Bill to talk about the 21-year deemed disposition rules. Get rid of that for you.
So to progress.
Arrow forward.
Okay. Good morning, everybody. I'm going to be speaking this morning about one of the, I guess, what I'd consider more interesting areas that I tend to get involved with in my tax practice, especially as I've gotten older. When I first started setting up family trusts, the 21-year deemed disposition rule seemed like some distant issue, like 21 years seemed like an awful long time. Now that I've been practicing for well over 21 years, I've certainly been running into many situations with trusts that are approaching the 21-year deemed disposition, and there's generally a significant amount of planning that should be done prior to the 21 years because there can be significant tax implications. Some of the issues I'll be looking at this morning are, firstly, is just a review of the 21-year deemed disposition rule, typical use for family trusts, one alternative, which is to allow the deemed disposition to occur. A second alternative, which is probably the most common planning technique, is to roll out assets from the trust prior to the 21 years. I'll discuss certain situations where you're not able to do the rollout from the trust. When that's not available, an alternative approach is making use of the what I call the vested indefeasibly approach. I'll consider some of the pros and cons of those two approaches, and also some of the key non-tax considerations, because when you're dealing with this, you're generally going from the situation where assets are held in the trust under the control of the parent and the trustees, and those assets are being transferred out typically to children directly. So there's a number of non-tax considerations that need to be dealt with. So what is the 21-year deemed disposition rule? I guess when setting up trusts, it's important to warn clients that this is one of the limitations on being able to use trusts, so that generally It may be available for only 21 years. Most clients regard that as a, substantial enough time to make it worthwhile, but it's important that they be aware that there is this time limit. There's various provisions in the Income Tax Act that trigger this deemed disposition. So whatever assets are in the trust on the 21st anniversary are deemed for tax purposes to be disposed of at fair market value. The impact of that is typically these assets in the trust will have a low tax cost. So if at the time of the deemed disposition, the assets are worth $10 million, you're going to have a capital gain of $10 million that you have to pay tax on. Often, if it's shares in a private company, it's bad enough paying tax, but there's generally zero liquidity to pay the tax. As I indicated, the 21 years can pass more quickly than you'd initially expect. I actually recently had my first occasion dealing with the 42-year deemed disposition. This is not like a one-time, it's every 21 years. I can tell you that I'm not that old, I did not set up that trust. But that's a first. I don't think I'll be practicing for the 63rd year. As I mentioned, the concern is that typically where the fair market value of the asset exceeds the tax cost, there's going to be a large amount of tax payable with often no liquidity. From a policy point of view, the reason for the rule is that the tax authorities do not want to allow you to defer capital gains tax forever in a trust. When an individual holds property directly, there's a deemed disposition on death that can be deferred to the death of the spouse. The 21 years itself is basically just an arbitrary period that was selected. It could have been 30, could have been 40 years. There are certain exceptions to the deemed disposition for specific types of trusts that have their own deemed disposition dates, which are the most common are qualifying spouse trusts and common law trusts and alter ego trusts. So there are some situations where the rule doesn't apply, but with most trusts, it will apply. There's various uses that trusts are commonly used for. What I typically run into most common is where a trust owns shares in a private corporation. This can arise in a number of contexts. Sometimes the trust becomes a shareholder when the company is incorporated. Other times an estate freeze is done and a trust is used to acquire the new growth shares. But it's quite a common situation to end up with trusts owning shares in a private corporation. Lorne's touched upon some recent tax changes. Some of those do have some adverse effects on prior advantages of using trusts, and in particular, the TOSI or income splitting rules can have, make income splitting no longer as attractive with a trust, but there are still many significant reasons why it will continue to be useful to have trusts owning shares. Some of the key advantages, if a parent wants to allow future or the possibility of future growth to go to children, I haven't run into a parent yet who would not prefer to retain control of that as long as possible, rather than committing and putting shares directly owned by the children sooner than they have to. It allows the trustees, including the parent, to decide later how the shares are going to be allocated. Another key issue in terms of flexibility is that if the trust is set up correctly to avoid certain tax traps, the parent can be among the, okay, I wasn't sure whether I'd kept up here. Oops. Okay. The parent or both parents could be included as discretionary beneficiaries, so the parents do not have to commit up front that all this value is going to go to children. The easiest alternative is to do nothing and just to allow the deemed disposition to occur. In some situations, that may be feasible, particularly if the assets in the trust do not have significant unrealized gains, so there's not going to be much tax. The other scenario is even if there's going to be some tax, if the trust has liquid assets to pay the tax, then that helps. There's certain steps that can be taken in terms of making use of capital dividend account and refundable dividend tax to reduce the value. Also, the planning doesn't have to be an all or nothing basis. A trust may have a series of different assets, so you could decide to leave some assets in the trust for the deemed disposition and to plan rollout for other assets. There is a special rule that is intended to help to deal with the liquidity issue. If the deemed disposition applies, you can elect to pay the tax over 10 annual installments. They're not giving that away. There's going to be interest payable on the deferred payment. As I mentioned before, the most common approach for planning for the deemed disposition is that under the Income Tax Act, there's a rule under Section 1072 that allows you to transfer out assets from the trust to Canadian beneficiaries on a tax-deferred basis. So this is very useful in many situations. But even assuming this rule and approach is available, there's significant planning that should be done rather than just simply rolling out whatever assets are there. There are various types of reorganizations of the shares that can occur before the rollout, and there's non-tax commercial considerations because, as I mentioned earlier, typically you're going to end up with children owning shares directly, so you're going to generally want to take steps like having family shareholders agreements, possibly limited purpose marriage contracts to protect the shares, and that takes some advanced planning time. As I mentioned, typically you're going to want to take some steps to reorganize the shares prior to the rollout. One issue is that while you may want to end up with a separate class of thin voting shares that can either be retained in the trust or owned by the parent, so the parent can retain voting control of the company. Another situation is if the parent is not going to end up getting any of these shares but would want the right to receive some dividends, you may want to create a separate class of shares for the parent that may receive dividends. One of the non-tax planning issues relates to Family Law Act protection. So the ideal scenario is to have children get limited purpose marriage contracts. If that's not possible, there are some things you can do unilaterally, including making use of the sort of gift exemption under the Family Law Act. So in terms of the possible reorganizations that you can do, one would be involve freezing the shares owned in the trust and then issuing new growth shares, which you could issue to a new family trust. So that would give the parent another 21 years for that future growth to decide how that's going to be allocated. One concern that often, or trade-off that often arises in a reorganization if you're doing a freeze, is that the so-called free shares generally have to be retractable to satisfy requirements of CRA. So you could end up with children getting shares worth a significant amount of value that the children have the right to demand payment of. Typically, parent doesn't want that. In some situations, parent is satisfied to trust the children that the children won't do that inappropriately. If the parent doesn't want to rely on trusting the children, there is protection that can be done by interposing another holdco that would own the retractable shares so the children do not end up with retractable shares. One restriction in the Act is that you cannot in terms of rolling out from one trust before the 21-year deemed disposition, you're not allowed to roll the shares out to another trust. There's a specific rule in the Act that prevents that. In terms of recent changes or clarifications from CRA, there has been a recent technical interpretation by which CRA has confirmed that it will more or less for sure apply the general anti-avoidance rule if you roll shares from one trust to a corporation, which in turn is wholly owned by another trust. So there's nothing directly that would prevent you from rolling shares from the first trust to a corporation. So technically, what aggressive tax planners might do was to try to accomplish indirectly what you can't do directly by setting up a corporation that's wholly owned by another trust. CRA has confirmed that it regards that as abusive, which doesn't really surprise me. So it would be definitely a high-risk scenario now to take that approach. In some situations, this most common rollout approach is not available. One common situation is that the rollout approach cannot be used for a non-resident beneficiary. So certainly in today's day and age, it is not uncommon to at least have some of the children who are non-resident. They might have been resident initially, but they might have moved to the US or somewhere else. So the rollout is not available to them. So you have to consider alternatives. Aside from the tax that would arise on the tax that would arise to the trust itself on the deemed disposition or a rollout to a beneficiary, there can be a second level of tax compliance with the non-resident beneficiary who's regarded as having disposed of his capital interest, which can require separate Section 116 reporting. What was considered a common planning alternative in this situation where you had a non-resident beneficiary was to roll out the shares to a Canadian corporation owned by the non-resident. So you were rolling out to a resident corporation, which technically would qualify. In terms of recent developments, there's been a recent technical interpretation where CRA says that it wasn't quite as strong as the prior situation, but certainly indicated that they may apply GAR in this situation where you transfer shares from a trust to a Canadian resident corporation that is owned by a non-resident. While the other technical interpretation did not surprise me, this one I do not necessarily agree with. So I would not, in a situation where you have a non-resident beneficiary subject to advising clients of the potential risk, I would not necessarily totally rule out this alternative. One of the issues that does come up is whether the trust deed itself specifically includes corporations as beneficiaries. So it's important in drafting the trust deed that you do allow that class of beneficiaries. If the trust deed does not allow that to do that, to treat a corporation as a direct beneficiary, the situation becomes more complicated as you have to consider whether the non-resident beneficiary can transfer on a rollover basis his interest in the trust to a Canadian corporation. It may be possible, but it's definitely much more complicated. Another key limitation on the rollout, which I would regard as one of the key income tax traps that you can fall into, and where it's crucial that in setting up the family trust and administering the family trust that you don't fall into this trap, because it is very easy to fall into. It's not a situation where it would be obvious to anybody that this would be problematic. But there's a rule in the Income Tax Act under 75(2), which is an attribution type of rule. and one of its primary effects is if it applies is to attribute income to a settlor or transferor, which is one problem to deal with. But typically the bigger problem is not the attribution rule itself, but there's a provision that provides that the usual rollout is not available at all if at any time 75(2) applied, even if there was no income. So in that situation, if you've got, say, the settlor of the trust and you've fallen into the trap, then so long as the settlor is alive, you cannot roll out to anybody other than the settlor or the settlor's spouse. So typically, if you wanted to roll out to children, you would not be able to do this. So there are rules that would, without getting into the detail, sections that prevent the rollout in this situation. The problem ends upon the death of the settlor. So if you fell into the trap and you were lucky enough for planning purposes that the settlor has died before the 21st year, you're okay, but certainly you can't count on that for your planning. The wording of 75(2) is such that it's not always totally clear when it would apply. There are numerous technical interpretations from CRA over the years as to when it thinks it's applying. There have been a number of tax court cases that didn't necessarily agree with some of CRA's position. But again, a key practical issue is that in setting up the trust is a crucial time to make sure it's set up to avoid falling into the traps. You definitely have a problem if the settlor of the trust is also a beneficiary, then you're definitely caught. Where it becomes dangerous, though, is that often in setting up a trust deed, you'll have a class of contingent or default beneficiaries who may take only in very remote situations, such as if all of your primary beneficiaries have died, and that mere contingency can be enough to cause the problem. Other problems arise if the settlor is also a trustee. So if the same person is a settlor and the sole trustee, you've definitely got a problem. One of the gray areas is if the settlor is one of two trustees. On my reading of the provision, you could be caught. CRA did give a number of years a technical interpretation that gave some comfort on that, but I would not want to be able to. I would not want to have to rely on that. There's too much at stake. The safest situation when you're setting up a trust is the settlor not be a trustee or a beneficiary. Alternatively, if the settlor is a trustee, to have a minimum of 3 trustees with majority decision. And 75(2) does not apply only to the settlor. Anybody who subsequently transfers any property to the trust can be caught by that. An even more dangerous trap is that CRA has taken the position if somebody pays any expenses of the trust, that could be viewed as a transfer of property, triggering this problem. So in situations where the rollout approach is not available, the alternative is what I call the vested indefeasibly approach. Technically, there's provisions in the Act that says that if all interests in the trust are vested indefeasibly, then the trust is not really considered a trust for this purpose, so the rule would not apply. There's some uncertainty as to what you have to do to have a vested indefeasible interest, but generally the interest has to be totally fixed for a beneficiary without any type of condition, even a condition of having to survive until a certain age. The nature of the vesting has to be such so as if the beneficiary dies while with this vested interest, that would be considered property of the trust subject to the normal deem disposition rule that occurs on death. Again, in terms of why it's important that the trust deed be prepared properly, if you want to use this approach, you have to check whether the trust deed allows you to do it in the first place. The trust interests don't have to be vested indefeasibly from the outset, but the trust deed has to allow you to do it, and they have to be vested indefeasibly before the 21st anniversary. If the trust deed does not allow it and you have to apply to a court for an amendment to the trust, this is a real pain in the neck, especially if you have any minor or unborn children. Generally, the government office of the children's lawyer has to get involved, so it's a very difficult process. Generally, if you've got a choice between the rollout approach or the vested approach, I would say in most cases, the rollout approach would be used. It's more commonly used and more certain as to its advantage. There are a few potential advantages of the vested approach. In terms of from a compliance point of view, if you're using the rollout approach, that transaction has to be reported on the trust T3 return, so it's something for CRA to possibly look into. If you're using the vested approach, there's nothing that needs to be reported on the return. Because of time restrictions, I'm not going to go into some of the other issues in the paper on the vested approach. In terms of non-tax considerations, while it's nice to talk about wanting to avoid the capital gains tax, as I mentioned before, you're dealing with the commercial situation where you're typically going to end up with children owning valuable shares in a company. So in every situation I'm involved with, I always certainly push and generally get a shareholders agreement, a family shareholders agreement done before the children become owners of the shares. I mean, some of the restrictions you're going to want on how the child can deal with the share. Typically, most parents who have set these arrangements up, if a child is getting shares, they generally want those shares to stay to the lineal descendants. They typically would prefer that if the child dies, the shares go to the grandchildren in trust for the grandchildren, not to the spouse of the child. There's a whole variety of issues that can be dealt with in a shareholders agreement. Time doesn't really allow me to get into them. A key issue is that it takes time to get this done. So it's not like you should wait till the month before your 21st anniversary and think that's enough time to deal with everything. The other key non-tax issue that I mentioned on is Family Law Act problem. Again, because the children are going to end up getting shares, parent generally wants to try to protect those from spousal claims. The best case scenario is to get a limited purpose marriage contract to protect the shares. That takes time. In the absence of that, there are steps that can be taken in the course of the reorganization that would allow the new growth shares initially to be issued to the parent. Parent then immediately gifts them to the children. That in itself, without a marriage contract, can protect those new growth shares from spousal claims. In terms of key takeaway points, I mean, this is a serious issue, the 21-year deemed disposition, because often there's very large amount of income tax exposure and often no liquidity to pay it. As mentioned, one of the key issues firstly in setting up the trust and considering your alternatives, what you can do is to consider whether 75-2 applied and whether that prevents you from using the rollout approach. It's important that the trust deed be carefully drafted to avoid some of the traps and to allow you to make use of the alternatives. Significant lead time is needed for proper planning for the 21st anniversary in terms of reorganizations of shares that are likely best to be done, shareholders agreement, and possible marriage contracts. There is no one cookie cutter solution that's best for all situations, depending on the type of shares, the corporation, the family dynamics. There are variables that need to be considered for each situation. Thank you.
Good morning, everyone. So I'll keep this fairly brief, but I will be reporting, as Lorne had introduced, the new trust reporting requirements from the 2018 budget. Now, the budget, which was released February 27th on 2018, has announced there are new reporting requirements that apply to certain trusts. The first are express trusts that are resident in Canada. So these are trusts that are created from the explicit instructions of a settlor. So these are what people usually think about when they talk about trusts, such as inter vivos trusts, testamentary trusts, discretionary trusts, fixed trusts, and bare trusts. Non-express trusts are trusts that are imposed by courts, such as constructive trusts and resulting trusts. So those are not affected by these new requirements. The second are non-resident trusts that are currently required to file a T3 return. So why is CRA doing this? The question is, why not? By way of background, we have seen a rise in the number of anti-money laundering laws and conventions that have been brought into the tax world. We've seen it recently in the UK, where they've implemented the UK Register of Trusts in accordance with the EU Fourth Money Laundering Directive in an effort to combat money laundering, terrorist financing, and organized crime. Now, whether or not these new measures will have the intended effect on tax compliance remains to be seen, but we are certainly seeing a trend in the demand for more information by tax authorities in an effort to discourage taxpayers from what they see as engaging in aggressive tax avoidance and tax evasion activities with respect to trusts. Luckily for us, Canada has also decided to jump on that bandwagon, and as a result, trustees are faced with additional reporting requirements and obligations and penalties for failing to comply with them. So under the current rules, trusts generally do not need to file a T3 return if the trust doesn't earn income or make distributions in a year. If the T3 return is filed, or it is filed if a trust has taxes payable, or if it distributes all or part of its income or capital to its beneficiaries. And where a trust is filing a T3 return for the first time, a copy of the will or a copy of the trust deed is included with the filing. Even if a trust is required to file a return for the year, they're generally not required to report the identity of all of its beneficiaries. So now effective for, under the new regime, which will be effective for the 2021 taxation year, where the reporting requirements apply to a trust, the trust will be obligated to file a T3 return and to provide additional information on an annual basis, including the identity of all trustees, beneficiaries, and settlors, the identity of each person who has the ability to exert control or override trustee decisions over the appointment of income and or capital of the trust. So these individuals are also sometimes referred to as the protector of the trust. The format of this new schedule to the T3 return has not been released yet, but I am sure it will be a delight when we get to see it. So there are a few trusts that will be exempt from the additional reporting requirements, which are listed as follows. So I can read them out loud or you can see them, but generally for us, we still see GREs, graduated rate estates, will be exempted, qualified disability trusts, trusts that qualify as nonprofit organizations or registered charities, and trusts that are fairly brand new, have been in existence for less than 3 months or hold less than $50,000 in assets throughout the taxation year. So what happens if a trustee fails to file a T3 return together with the schedule containing additional information? There will be a penalty equal to $25 for each day after the filing deadline, with a minimum penalty of $100 and a maximum penalty of $2,500. If the failure to file was intentional or was due to gross negligence, there will be an additional penalty of up to 5% of the maximum fair market value of property held during the relevant year of the trust, with a minimum penalty of $2,500. And of course, the existing late filing penalties will also still apply. So in summary, the additional reporting requirements will pose a heavy burden on trustees for resident and non-resident trusts alike, and it remains to be seen how effective these new measures will actually be. Thank you.
In closing, are there any questions? Please give us your evaluation forms, and we will be remaining here for anybody who wants to come up and ask us questions. Have a great summer, and we hope to see you in the fall.